pertaining to Aizol bench. Item 1, WPC 40 of 2026.
Impugn order stands set aside and cause some matter remanded to the Information Commission, State Information Commission.
Oblige, my lord.
Oblige.
Items pertaining to principal seat for delivery of judgment. Item 49, PRP 70 of 2019.
Petition allowed. Matter stands remanded to the learned First Appellate Court.
Item 50, MFA 7 of 2026.
Appeal allowed. Impugn judgment and order passed by the claims tribunal stands set aside.
Petition item 1.
Commercial quantity. What may kindly be called?
Under which section the case was registered?
21B. 1B.
51B.
Whether surset is submitted in this matter?
Pardon?
Whether surset is submitted here?
Well, I am not sure, my lord. I am not sure.
Instruction.
No, this is not of commercial quantity.
Yes,
The case is registered under section 21B.
My lord. My lord, they are behind the bar for more than 3 months, near about 4 months. My lord.
No, you obtain instruction of whether surset is submitted here or not. Both of you,
My lord.
after some time.
My lord, kindly wait.
No. He will obtain instruction whether surset is submitted or not. If surset is not submitted, we will grant you default bail today itself.
Oh, thank you.
May I plead, Lord? Matter relates to my lord. NDPS Act, my lord. It was arrested on 7/7/26, my lord. Already 14 Mondays, my lord, the entire farm, my lord. My lord, 80 number of cough syrup recovered from my possession, my lord. 9.
Surset is not submitted here.
My lord.
Surset is not submitted.
Arrested on 8/7/26, NDPS commercial quantity.
Commercial quantity, let us say it.
Yes.
City on Bordago.
On my lord,
28.
20.
Okay.
Item 4.
This is also your lordship. Yes, commercial quantity.
Commercial quantity.
Yes. Not 7.
Sorte bade. Bordago city on.
CD on my lord. Did I get it?
At 3 and 4.
Yes. On 28.
May I please, Lord?
It was that he was in custody for last 61 days. 90 days it is mandatory here. Earlier lordship has rejected at the early stage of investigation at 40 days. But apparently it's a case of 498A, 87 of the BNSS. That they are living together as husband and wife since 2020. And now allegation is that I have developed some kind of relationship with another woman now. So basically, basic allegation lordship will find the FIR at page 12.
At what stage the case is pending?
My lord.
At what stage investigation completed?
Investigation is I am in custody, my lord. for last 61 days.
No, investigation is going on.
Going on, still going.
So what is the new ground? This was rejected only on 27/7/20.
My lord, last 20 days, my lord, before I have filed it. Now apparently, my lord, 20 days has gone. I think other custodial detention, basically allegation lordship kindly see, maybe 498A basically. Only allegation that I have developed some kind of relationship with another woman now. And we have married since 2020. We are living as a husband and wife in a rented house. From 2020.
No, to substantiate that you have married, is there any document
No,
also?
no, sorry, herself is she, herself came it, my lord. Page 17, vernacular. Page 12 is the translation, my lord. Court marriage on Borpeta 21/8/2000.
Do you have the marriage agreement with you?
Yes, marriage ended. That is
No, the copy of marriage agreement is with
No,
you.
I don't have. But herself, she has stated that, and thereafter they are living together in the rented house. Next line, Lordship will find. Because the people from the family, they objected, so 2000 onwards, they স্বামী স্ত্রী হিসাবে থাকে রাতি গুছি যায় আকো আহে and now I have
No,
developed
that's all right. Can you produce the document?
document I don't have, that is her claim itself, my lord, there that the
If it is possible, you produce it at 2 o'clock today.
the day after tomorrow, my tomorrow, my lord.
Tomorrow. Okay. Recess list this matter tomorrow.
I can say.
No,
But-
I insist upon production of that document only because earlier it was rejected.
My lord.
Therefore,
Problem, no problem. But one more item, probably they want to file the objection, item number 24, my lord. 24,
yes, criminal appeal.
yes, ma'am. They'll file the objection, my lord. Next week, then, my lord.
Okay.
2 weeks.
As agreed by learned advocates of both the parties, recess list the matter on. Copy
Appeal may be admitted, my lord.
today.
Today, my lord. Appeal may be admitted for IA, my lord, objection.
TCR has to be scanned.
Okay. After 2 weeks.
After 2 weeks.
Okay.
Okay.
My lord, as regard item number 1, I have got information from the advocate of Morigao district. The case has been charge sheeted very recently.
Substitute.
Please also the record.
Copy.
Charge sheet is submitted. Item 1.
Okay, scan copy of the record then.
How much scan copy of the record?
Scan copy of the record on. Recess will call for the scan copy of the record on.
From the session judge Morigao, my lord.
From the special judge NDPS Morigao, fixing the matter
On 2nd September.
2nd of September.
I know a bit early here. It is Morigao, my lord. A bit early, my lord.
On 26th August.
26. They apply.
Item 6.
26 August. One is here to commercial one is
From who is PS? From who is PS? Sri Bhumi. Okay. So Porter shall produce the case diary before
Yes,
this court on.
On my lord.
My lord, 2nd of September.
2nd of September. Okay.
Item 7.
Next. They need to undertake it. Undertake it, my lord.
Pardon?
For the scale of petition.
Oxo,
Yes, madam.
search it submitted
Yes, madam. Undertake it.
under try. Okay. raises the issue notice to the respondent number 2 through the Office of the Public Prosecutor, Gauhati High Court. And also call for the scanned copy of the record from the learned trial court. List the matter on. Sorry.
Not September.
On that day, Mr. Bortakur shall produce a service report upon respondent number 2, having obtained the same from the officer in such jurisdiction in this.
Item 8,
Made physiological. Sir, connected matter is listed before this court tomorrow. The PA number 2274 of 2026.
CD call for?
CD is called for that will come for bail hearing tomorrow.
Tomorrow.
Item number 29.
Okay. But Mr. Bhatta says in learned counsel for the accused. This application under section 483 of the BNSS 2023 is prepared by the accused. Prepared by accused Vinit Kumar Poddar, alias Vinit Poddar, who is languishing in jail hazard in connection with the Special Task Force, Police Station, Assam, case number 02 of 2026 under section 61(2), 318 within bracket 3, 319 within bracket 2, 336 within bracket 3, 338 stroke 340 within bracket 2 of the BNSS 2023. Mr. Bortakur, oh no, Mr. Bhatta submits that connected matter is listed tomorrow and in being BA number
2274.
2274 of 2026. And in that matter, the CD has been called for. And tomorrow, this matter may be listed and CD may be perused to dispose of this matter also. Accordingly, it is provided that registrar shall list this matter along with BA number so and so. And tomorrow, the CD will be perused to dispose of this present application also.
Apply.
item 9. Will be called for, sir.
I first.
Let's call for this.
After some time.
Let the affidavit be. Item 10.
That is incident case 93. Here noted the petitioner filed one discharge application on the ground that no witnesses has implicated the present petitioner. So although charge sheet was filed against him, the documents which were furnished to him shows that none of the witnesses implicated. And on that ground, he filed discharge application, and that discharge application also, if your lordship peruses at page 27, clearly it is, the statement is there, page 27. That out of 17 witnesses, none of the witnesses implicated the present petitioner, lordship. And regarding that, lordship, no lordship observation is made in the imperial order that any of the witnesses implicated him or there is any material to raise suspicion that he is involved in the offense, lordship. Merely that page 33 imperial order, it is said that on perusal, page 33, lordship. On perusal and meet on perusal of the case record and case diary and after the start hearing and copyright on this court is of the view that the accused persons have committed our offences under section 7 according to charges under the IPCR code. Here also altogether 5 persons are facing the trial, and out of them against this present petitioner, no witnesses made any implicating statement. In fact, also I have enclosed all the statements also from page 34 onward. My learned friend can verify and submit that if anything is there or not.
No, verify means he has to verify it with the original record. Let the record come.
Is there not against this present petitioner maybe state?
No. We'll finally hear and dispose of the matter. Let the scan copy of the record come. Heard Mr. Ahmed, learned counsel for the petitioner. In this petition under section 528 of the BNSS 2023, read with article 227 of the Constitution of India. The petitioner has challenged the order dated 8/7/2024 passed by the learned additional session judge number 2, Nagaon, in session T1-24/2023, whereby the learned trial court has dismissed the discharge petition number 566 of 2024 filed by the petitioner and framed charge against him under section 447, 326, 302, 34 IPC and fixed the matter on 1/10/2024 for PW for prosecution witnesses. Mr. Mr. Ahmed Learned Counsel for the petitioner submits that the petitioner herein is not implicated by any of the witnesses examined under section 161 CRPC. And there is no incriminating materials against him, and as such, the impugned order dated 8/7/2024 suffers from material irregularity, and therefore he has contended to allow the petition. The submission of Mr. Ahmed needs further consideration. At this stage, notice be issued to the respondents returnable on COVID. 14th of September. Step upon respondent number 2 be taken by speed post and also by usual process within a week from today. No formal notice is required to be issued to the respondent number 1 since Mr. Borthakur entered appearance and received notice. However, extra requisite copy of the petition be furnished to him during the course of the day. Registrar shall call for the scanned copy of the record along with the case diary from the learned trial court. An interim payroll will be considered on that day.
Obliged.
11.
Please, Your Lordship. Also, the petitioner was convicted under Wildlife Act. Actually, 51 of Wildlife Protection Act. And he also filed an interlocutory application, Your Lordship, under section 430 of BNSS.
Then, my lord, I will have to inform my lord,
Praying for suspension.
special PP, my lord. Wildlife factor, how is it?
Wildlife Act, no, I am praying for something else now, Your Lordship. Actually, Your Lordship, that IA criminal was allowed by this honorable court, Your Lordship, suspending the order and granting bail to the petitioner. And certain conditions imposed upon the petitioner, Your Lordship. Your Lordship will find the order on page 11, 12. And Your Lordship, the petition. Now, the first condition was, Your Lordship, that the applicant appellant is directed to be released on furnishing a bond of rupees 30,000 with the surety of the like amount, subject to the satisfaction of the learned session judge Batra as Musal. And the second is the applicant appellant on his being enlarged on bail is directed to report before the session judge Batra and Musalpur on all Mondays and Fridays at 10 AM with the disposal of the applicant pending before this court. And Your Lordship, he has been appeared. He appeared before the session judge, and that order, Your Lordship, will find on page 14, Your Lordship. The order dated 18/12/2025, where his bail bond was submitted, and Your Lordship, the bailor submitted his bail bond, Your Lordship, but then, Your Lordship, the learned session judge, he asked the bailors to appear along with the petitioner on every Monday and Friday, Your Lordship. The bailors as well as the petitioners filed 2 petitions to dispense of the appearance of the bailors on Mondays and Fridays, because that those petitions were dismissed by order.
No. What was the direction issued by this court in IA criminal number 808?
Yes, Your Lordship, that I have annexed on annexure 1, Your Lordship.
Hmm.
That the applicant, Your Lordship, will find on page 12 of the Lordship.
Hmm.
That the applicant is directed to be released on bail on his furnishing a bond of rupees 30,000 with 2 sureties of the like amount, subject to the satisfaction of the learned session judge Batra Musalpur. The applicant appellant on his being enlarged on bail is directed to report before the session judge Batra at Musalpur on all Mondays and Fridays at 10 AM till the disposal of the appellant pending before this court. Your Lordship, he is appearing, Your Lordship, on Monday and Friday. Now the session judge Batra is of the opinion that the bailors shall also have to appear along with them, which is not a part of the direction, Your Lordship, by this honorable court, Your Lordship. So they are being subjected to unnecessary hardship, Your Lordship.
Now, when a petition has been filed by the bailors as well as the petitioner, your lordship, the learned session just says that, your lordship, it is beyond his jurisdiction, since the order has been passed by the Honorable High Court. But the Honorable High Court has not passed any such order, your lordship, where it has directed the bailors also to appear along with the accused, your lordship.
Yes, Mr. Sharma.
Yes, my lord, the condition number 2, that is, my lord, clear, directly to report before the session on Monday and Friday. Is that to the petitioner? Actually, my lord, the condition, my lord, B, my lord, that direction, my lord, apparently goes to the, my lord, to the petitioner, not to the bailor,
Not to the bailor.
my lord. তো এজনে আছিল।
Yes, yes. Not.
Kindly come to page 20 to last page, my lord. Also direct accused persons. Person.
No, here you ought to have challenged the order dated 1812 by which the bailors were directed to produce the accused person before the court.
Your lordship,
Condition number 8, para number 8, page number 15.
Yes, bailors are directed to produce the accused person before this court. as
Yes,
per
you have not challenged this order.
Your lordship, I have filed a petition, 2 petitions, your lordship, against that order, your lordship, that we may be dispensed of the personal appearance, your lordship. Then those petitions were rejected by this order, 13/3/26, your lordship. So I'm challenging this order, your lordship. Verified, your lordship, I agree, your lordship, the Honorable High Court has directed the accused person to appear before the court on each and every Monday. Your lordship, then your lordship, accordingly, the prayer so made by the bailors is beyond the jurisdiction of the court. And the order is passed by the Honorable Gauhati High Court, and accordingly, the petitioner by excellence so stands rejected. Fixing 16/3/26 for appearance of the accused person with your bailors. As per the order of the Honorable Gauhati High Court. Your lordship, there is no such order of the Honorable Gauhati High Court. Your lordship, asking the bailors to appear with the accused persons, your lordship. So this is misinterpretation of the order of this Honorable Court.
Yes, Sharma.
Yes, currently there is.
Heard, Mr. What is your name?
I say, MDI.
Learned counsel for the petitioner, and Mr. D. Sharma, learned additional PP for the state research, special PP. Oh, forest department, no,
Well,
forest
Special
department. In this petition under section 538 of the BNSS 2023, read with section 4/2022 of the BNSS 2023, the petitioner has challenged the order dated 13/3/2026 passed by the learned sessions as Baksa. Police, it is to be noted here that by the impugn order dated so and so, the learned Sessions Judge Baksa has rejected the pair of the petitioner as well as his bailors in petition number 637 of 2026 and 638 of 2026 from dispensing their personal appearance on each and every month. No, each and every Monday and Friday. Learned counsel for the petitioners submits that the petitioners are bailor.
No, the petitioners are the accused persons, your lordship. Now,
That the accused person, no, that the petitioners are the accused person in. Accused person in. What is the case number in which you were?
the WL bracket P case number 12 of 2018.
In special wildlife, written bracket P case number 12 of 2018. There you have been convicted.
Yes, your lordship.
And in the said case, the petitioners, only one petitioner has filed this petition.
Yes, your lordship. Only one.
The petitioner, namely Ali Ahmed, was an accused and he was convicted by the learned trial court. Thereafter, the petitioner has preferred on criminal appeal number 284 of 2025, challenging the impugned judgment and order dated 13/6/2026. And in the said appeal, the said appeal was also admitted for hearing. And in the said criminal appeal, the petitioner herein has filed one interlocutory application which was registered as IA criminal number 808 of 2025. And while disposing of the said interlocutory application, this court, a coordinate bench of this court was pleased to direct the petitioner to appear before the learned sessions as Baksa, Mosolpur on all Mondays and Fridays till disposal of the criminal appeal pending before this court. Thereafter, the petitioner herein has filed bail bond before the learned sessions judge. And by order dated 18/12/2025, while accepting the bail bond, the learned sessions judge by order dated 18/12/2025 has directed the bailors of the petitioner to produce the accused persons before the court on each and every Monday and Friday. The learned counsel for the petitioner further submits that this court, while granting bail to the petitioner by order dated 11/12/2025 in IA criminal number 808 of 2025, has never directed the bailors to produce the accused, produce the petitioner before the learned session judge, Baksa. But in spite of absence of such direction, the learned session judge has directed the bailor to produce the petitioner before the learned session judge. Now, before it on every Monday and Friday. Thereafter, the petitioner herein has filed two applications, being petition number 637 of 2026 and 638 of 2026 for dispensing with their personal appearance of the bailor on each and every Monday and Friday. But by order dated 13/3/2026, impugned order dated 13/3/2026, the learned sessions judge has dismissed the petition on the ground that This court in IE criminal number 808 of 2025 dated 11/12/2025 has directed the accused person to appear before the court on each and every Monday and Friday. And as such, the bailor is as such, the pair made by bailor is beyond the jurisdiction, as the order is passed by this court, and accordingly dismiss the same. The learned counsel for the petitioner further submits that the impugned order is illegal and arbitrary, as there is no such direction in the order dated 11/12/2025 passed in IA criminal number 808 of 2025, and therefore he has contended to dispense with, to allow the petition by dispensing with the appearance of the bailor before the learned trial court, before the learned session judge Baksa on each Monday and Friday. Mr. B. Sharma, learned special PP for the wildlife. The respondent herein has fairly submits that in the order dated 11/12/2025, this court in IS criminal number 808 of 2025, this court has never directed the bailor to produce the accused person before the court. Instead, only the accused persons were directed to appear before the learned session judge. And as such, the impugned order, according to Mr. Sharma, is illegal. Having heard the submission of learned counsel for both the parties, this court has carefully gone through the petition and the documents placed on record, and also produced the order passed by a coordinate bench of this court in IA criminal number 808 of 2025, and also the order dated 18/12/2025 passed by the learned session judge, and also the impugned order dated 13/3/2026. Indisputably, in the order dated 11/12/2025, no direction was issued to the bailor to produce the accused persons, the petitioners before the learned, the petitioner before the learned session judge Baksa. And in that view of the matter, the further in the impugned order dated, by order dated 11/12/2025, a coordinate bench of this court has never granted any liberty to the learned sessions as to impose any other condition. And in that view of the matter, the impugned order dated 13/3/2026, directing the bailor to produce the accused persons before the learned session judge on each and every Monday and Friday is illegal and without jurisdiction, and accordingly the same stands set aside in cost. However, the petitioner hearing shall appear before the learned session judge on each and every Monday as per direction of this court in the order dated 11/12/2025 in IA criminal number 808 of 2025, in terms of this petitioner's disposal.
Item 13.
But this revision petition number. Any of the recurrent pending of the learned trial court as well as the first appeal court. Case is under section 138 of the NI Act. Take amount was 4 lakhs, LSD 2 checks on the same day amounting to rupees 2 lakh each were issued money. And both got dishonored. And subsequently, the fine was imposed for an amount of rupees 6 lakh. Lordship, my only respectful submission at this stage, the law point involved in this case, my lord, as per admission of the PW1, that is the respondent, my lord, during the cross examination, he have specifically stated that the postal receipt that was obtained is by manipulating the postman, my lord. That is first point, my lord. Secondly, my lord, his admission is that, my lord, his annual income is
Let the record come, we will see.
regarding the suspension of sentence, my lord. Otherwise, the
What is the sentence?
IA is there, my lord.
What is the sentence?
Lordship, SI for 6 months, lordship.
6 months. Okay. Call for record from the issue notice. List the matter after 4 weeks. IA is then suspended. Okay.
Obvious.
Item 14.
If the condition, against the present petitioner along with 4 persons matter. And this was registered, this was 304B man. And thereafter, the investigating agency completed the investigation, submitted the sheet against the accused along with other accused. Case 17 is now that. Case 17, the order of the first order of the court. The CS receipt is 171. Accordingly, cognizance was taken, and next case 20 minutes, 20. He was arrested initially and reduced to appeal. And case 20 minutes, he was paid to appear and could not contact with his counsel also. Case 20 minutes. Earlier minute, he was regularly appearing for his counsel, and sometimes he also. And case 20, without any station, the present accused person was absent, and NBW was issued, and subsequent order, that is case 54, last page of the petition. Now, NBW and proclamation against the accused petitioner, So my humble submission, that he stated in the petition, that admitted fact, he was absent. And paragraph 6 and 7 of the petition, I have stated, he report person, and his house was eroded by the river, and he went to Aryan for his livelihood. And some debt he was contact with his engaging counsel, and subsequently, he could not contact, and no step was taken. So I am praying, that he is ready to face the trial under any terms conditions. So on his court, they allow him to go on. Initially, he was arrested and he was released.
Yes, Bordakar.
Yes, my lord, since my lord, 12/11/24, my lord. Appeared before the trial court, my lord.
First warrant is case 20.
Only till the date of his appearance, my lord. NPW.
Case 20 is the first NBW.
Let him appear, my lord, first.
Subsequent all order. He is the maternal uncle of the main accused. In fact, he is not involved with the case, but I am not on this ground because Kashi did.
Only till date of his appearance.
Okay. Heard Mr. Uddin, learned counsel for the petitioner. And Mr. Bordakar, learned additional petition for the state respondent. In this petition under section 528 of the BNSS 2022, the petitioner has challenged the order dated 12/11/2024. And also the order dated 29/5/2026 passed by the learned Chief Judicial Magistrate Barpeta, whereby non-bailable warrant of arrest was issued. Along with the proclamation was issued against the petitioner, fixing the matter on 38/7/2026 for appeals. Mr. Uddin, learned counsel for the petitioner, submits that the petitioner is an accused in PRC case number 611 of 2018 under section 304B/34 IPC. And in the said case, he was appearing regularly before the learned trial court. Before the court of learned additional Chief Judicial Magistrate Barpeta, but on account of his livelihood, he left for Haryana and he could not appear before the learned court below on 12/11/2024, and also his counsel did not take any step for which the learned additional chief judicial magistrate Barpeta has issued non-bailable warrant of arrest against him and continued to issue the same till 29/5/2026. Mr. Uddin further submits that the petitioner is ready to face trial and he may be given a chance to appear before the learned trial court to face the trial, and therefore he is contented to allow the petition. Mr. Borthakur learned additional PP submits that till the next date, the warrant of arrest issued against the petitioner may be kept in abeyance, affording him an opportunity to appear before the learned trial court. Mr. Uddin submits that the next date is
27/11.
27/11/2026.
27/11.
Accordingly, taking note of the submission of learned counsel for both the parties and also considering the facts and circumstances on the record, this court is inclined to dispose of this petition at this motion stage itself by directing the petitioner to appear before the court of learned additional chief judicial magistrate Barpeta on or before 9th of September and to apply for regular bail, and in the event of filing such an application, the learned additional CJM Barpeta shall consider the same in accordance with law. Till then, non-bailable warrant of arrest issued against the petitioner shall be kept in abeyance.
Item 15,
My lord, I don't kindly pass on the method for the day, madam. As before any condition, learned counsel aid of
On the appear being made by Mr.
H
Learned counsel appearing on behalf of
on behalf of aid of
this petition stands adjourned for the day.
item 16.
An application under section 5.28. I will trouble you a lot. First page. The affair. Dated, my lord, your lordship will find in the right hand side. 5/11/2020, page 44. 5/11/2020. My lord, is against so Utapani Shawar Shawati. Along with all the official board of directors. The big affair, irrigation is they are misappropriated both and others, so there is that ultimately the sections are at page 48. 120B, 420, 468, 471, 7 of EC Act, and ultimately charge sheet 5. But I will say again, trouble your lordship to page 22. This is dated by lot 7/10/2020. 7/10/2020, page 22. But against this society, again, there was the similar type of an affair against that. Against the same society at Borpeta, Khalgachia, and this was also registered, and at page 43. Court has taken cognizance.
No, which is the FIR on the basis of which the trial court has taken cognizance?
My lord, the first FIR was on at page 22 on 7/10/2020 against the society along with this 4%.
And the next FIR?
Next FIR is at page 44. One
44.
thing I have to admit to a lordship, my lord. First FIR, they are giving the name of the society, but our names were not there in the first.
But the name of the society along with the employees was second FIR, our names are specifically. That I have to admit to a lot.
Okay, let notice go at this basis. Let the record come. Let what is since the proceeding is pending.
The second case was stayed at page 81 as respect 4%. Page 81.
Let the record come, we will consider your pair.
Well,
This will not is returnable in 4 weeks. It's the bit taken by speed post and also the usual process, so they never do that. However, no formal notice is required to be issued since Mr. Portaker entered evidence and received notice. Rest shall call for the record from the learned trial court. Interim period of the petitioner will be considered on receipt of record from the learned trial court.
17.
Same order is possible find at page 64. Where is it?
64.
There in the second line of also Lordship may kindly note that the case was at the stage of the framing of charge. I filed discharge application and without deciding my discharge application, this order was passed.
How you are agreed by this order?
So kindly see that the case was initially registered under section 379. That was a charge. So I have produced all the valid documents that I have purchased it and accordingly Zimma was also given to me. And on that basis, I filed a discharge application. If the prosecution have a case of 379, that will proceed. Lordship. But at the stage of framing of charge, without any application from the prosecution side, that court cannot proceed on suo motu direct for further investigation. And the third ground is Lordship that they have the learned trial court has directed the customs officials to investigate the case. And as per judgment of our High Court Lordship, it is held that the officer in charge of a police station can be directed to conduct a further investigation. Other agencies cannot be directed to conduct a further investigation. Because in, as per definition of the now BNSS Lordship, that officer in charge means a person who is holding that station house. So other department will not come as an officer in charge. They can be the investigator, but they are not the officer in charge. So in view of that also.
So when cognizance was taken?
The cognizance was taken long back by the committal court and thereafter case was committed to the court of session.
Where is the order of taking cognizance?
Page 44.
44.
Whether for my submission, your lordship is that, whether further investigation is required or not, or that has to be decided at the stage of, lordship, taking cognizance, lordship. And if any further direction is given, that has to be given with an application.
No,
of-
page number 44, it is just an administrative order transferring the case to the Court of Learned Additional Sessions as number 2.
But that magistrate order, your lordship will find page 42, I'm sorry.
Page 40?
42, yes.
No, here, it has not been mentioned about taking up cognizance.
That word is not there, but if your lordship see the last line of page 42,
Hmm.
the charges has been laid under section 7 also against the accused.
Hmm.
Then as the offence under section 20 is exclusively triable by the honorable court of session, as the case record is committed to the honorable court of session for trial. Then the case records, case diary along with relevant documents. Notify learned public prosecutor about the commitment of this case, inform all concerned. So that charge was accepted. And in fact, lordship, if your lordship.
No. Acceptance of search sheet and taking cognizance are two different things. In where the learned magistrate or the learned court has applied its mind.
So that your lordship will find page 44, lordship, that case record was seen and therefore it was directed to be registered as sessions case, lordship.
Mhm.
And therefore the case was fixed for lordship at the stage of framing of charge. And in fact, lordship, page 3, that shows that I find my discharge application.
So,
on
yes,
festival
Bortakur.
26. Page
Whether at the stage of framing of search, the court can direct reinvestigation.
Yes. What basis for the protest?
First that order, my lord, again handing over the customs.
Hmm.
So you'll also at this stage records may be called for, my lord. Scan copy of the. Otherwise, whether any, my lord, any application was filed in that regard, my lord, by the.
Our High Court has already decided that except police, other department cannot be lordship directed to conduct further investigation. That I am just placing before lordship. So had it been a case that that same office police station is directed, that also it will be seen a different aspect. Paragraph 15 to 18, lordship may add this to it.
Otherwise, it cannot be said that, my lord, on the basis of the materials on record, my lord, there is no.
No, this decision will not help you.
Another judgment, lordship, honorable effect for that.
Okay, Mr. Amit, let the record come. In the meantime, let Mr. Bortakur go through the relevant
Yes,
provisions.
yes, ma'am.
And
Otherwise, my
after
lord,
this,
Lordship, kindly see that Supreme Court judgment which I have just given. Lordship.
Hmm. Hmm.
Paragraph 17, last, 8 lines of the paragraph, of paragraph 17. Because here specific direction was given to which direction investigation has to be conducted. That's probably a mistake cannot.
No, it's,
But like that, customs will conduct an investigation, and to what extent that is also reflected in the order. That jurisdiction probably that magistrate do not. In what angle that investigation has to be carried out, it is the discretion of the investigating officer. So if any further material is required, we could have directed for further investigation. That pointing out the director probably. I am referring to.
No, no,
Paragraph 17, last 8 lines.
From the order, my lord, itself reflects that, my lord, learned trial court has not, that investigation should go into a particular direction. But considering the, my lord, materials, it cannot be said that
he has no power.
he has no power that, my lord, further investigation for, if suppose, my lord, there are scope for further investigation, definitely, my lord,
There was no
trial
application
magistrate
from
can, my
the
lord.
prosecution side, that is the. Because regarding that further investigation.
No, whether the magistrate or the court is diverted from
This order was passed at the stage of framing of charge, not at the stage of taking cognizance.
No, Mr. Ahmed, you have failed to show by which order cognizance was taken.
That's page 44.
67.
44. By this is administrative order, the case is transferred to the court of additional sessions as number 2. Let the record come. Heard Mr. Ahmed, learned counsel for the petitioner. Then also heard Mr. P. Bhatta for learned additional briefing for the state respondent. In this petition under section 528 of the BNSS 2023, the petitioner has read with section 227 of the Constitution of India. The petitioner has challenged the order dated 17/6/2026, passed in session case number 27 of 2025 by the learned additional sessions as number 2, Kamrup M. Gauhati, whereby the learned trial court has directed further investigation of the case. Mr. Ahmed, learned counsel for the petitioner, submits that the petitioner the petitioner was succeeded in the above noted case under section 120B, 379, 411, 413, 410, and 420 IPC. And thereafter, by impugned order dated so the learned trial court has directed further investigation of the matter. Under the Custom Act, and also directed the officer in charge GRPS Gauhati to hand over the case diary, including the seized material, to the Zonal Director Custom Division Gauhati for further investigation under Custom Act. And that the impugned order is illegal and arbitrary, and therefore he has contended to set aside that same. The submission of Mr. Ahmed needs further consideration, and this is this. Notice be issued, returnable on.
On 3rd September.
However, no formal notice is required to be issued since Mr. Bhatta entered appearance and received notice for both the respondent Our extra requisite copy of the petition we furnished to him during the course of the day. Registrar call for the record from the learned trial court. Scan copy of the record. Place the matter on. Takes a very short date. Interim care of the petitioner will be considered on receipt of record from the learned trial court.
26. Item 18.
Yes. Page number?
Page number 25. The landed relevant page number 29 and 34. Landed section entirely set aside and watch the trial court order without fixing the quantum of the maintenance. Landed trial court at least the maintenance is 5,000 for the wife and 3,000 for the sheep. Landed section the entirely set aside and remanded back the. It is in page number 30, last chapter. Also, both the parties are access their evidences here. On page 30, try here.
Heard, Mr.
The
Learned counsel for the petitioner. In this petition under section 530, 438/422, read with section 528 of the BNSS 2023, the petitioner has challenged the judgment and order dated 17/1/2026 passed by the learned session judge Shivami in criminal appeal number 12 of 2023, whereby the learned session judge Shivami has allowed the appeal and set aside the judgment and order dated 38/6/2023 passed by the learned Chief Judicial Magistrate Karimanganj in Miss DV case number 373 of 2018 and remanded the matter for a fresh adjudication. So what wrong with this order?
My lord, will close both the parties that addresses their evidences, your lordship. And without considering that evidences, your lordship, this first order has been passed. And this is page number 29, my lordship, 10, para number 10, my lord. Because he's supposed, Bharat session is supposed to fix the quantum of the maintenance, your lordship, or modify the maintenance, my lord. No maintenance has been fixed, my lord. Directly mechanically set aside the entire order of the trial for my lordship, because started in 2018, your lordship. At least you should consider the child maintenance, your lordship. No quantum of maintenance has been fixed, my lordship, neither it's modified, my lordship.
Where is the judgment of the trial court?
My lord, there is in page number 15, my lord. 15. And my lord, relevant paragraph is page number 21, para number 7, my lord.
You follow line two? Hmm. It is to be noted here that by judgment dated 30th/6/2026, the learned Chief Judicial Magistrate Karimganj has directed the respondent herein to give a sum of rupees 5,000 to the complainant and rupees 3,000 to her son as monthly maintenance allowance from the date of filing of the complaint until further order. The learned counsel for the petitioner submits that the learned session judge might impugn judgment and order dated so and so without considering the evidence adduced by the parties, has set aside mechanically set aside the judgment passed by the judgment and order passed by the learned trial court dated 30th/6/2023. 2023. And at least the respondent herein may be directed to continue payment of maintenance to the child. To the child. Heard. Having heard the submission of learned counsel for the petitioner, this court has carefully gone through the petition and the documents placed on record. Let notice be and also produce the judgment, impugn judgment and order dated so and so passed by the learned session judge Srivami, and also the judgment and order dated 30th/6/2023. Let notice be issued to the respondent returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today. Recess will call for the record from the learned trial court as well as from the court of learned session judge Srivami. And pending further consideration, the respondent herein is directed to continue payment of a sum of rupees 3,000 to the minor son of the petitioner till disposal of this petition. List after 4 weeks.
I'm ready.
Item 19.
Yes.
My lord, in this case, I am paying for quashing of a proceeding matter. My lord, FIR has been filed by the Vishwa Hindu Parishad, my lord, President of Vishwa Hindu Parishad, my lord. Against the accused person, alleging that, my lord, a Facebook post has been published regarding illegal transportation of coal mine from Borak Valley, my lord. This is the allegation, my lord. Therefore, my lord, charge sheet has been submitted under section, case has been registered under section 295A. Thereafter, my lord, charge sheet has been filed under section 295A and 67 ITA. My lord, thereafter, my lord, Chief Judicial Magistrate took cognizance of the case under section 295A, page number 29. 295A and section 67 ITA. The lordship is there, my lord, as per section 196(1) of CRPC, my lord. Prior sanction is required from the state government or the central government to take cognizance of the case under section 295A. But here, there is no sanction, my lord. And
As per section 196
196
of CRPC.
Yes. I'm paying.
So no sanction was obtained.
Then, my lord, uh, my lord, 295A offense regards illegal transportation of oil, my lord. My lord, 295A, what is 295A, my lord? Insulting religion or religious groups. That is separate, my lord, section is inflicted here. 295A, my lord, insulting religion or religious beliefs. That is the 295A. And FIR contention is the illegal transportation of coal, my lord. So incidence and section is not handy. Thereafter, my lord, 67 is also publishing obscene materials in electronic form. 67. Here, my lord, it is not obscene, my lord. Illegal transportation of coin. So, my lord, charge.
Where is the FIR?
FIR page number, my lord, 15. Type 2. Facebook post, my lord, page number 13 also. There is no obscene material. And the petitioner is the journalist, my lord. My lord, page number 13.
No.
In the Facebook post.
Here the Bajrang Dal has been involved and implicated in the Facebook post.
Page number 13, my lord.
Okay, let notice go. Heard, mister?
Thereafter, my lord, another equal, my lord, page number 39.
39 relates to what?
My lord, formal charge has been taken, my lord, against the petitioner under section 5051C, my lord, page number 39. There in this case, my lord, as per 196A, my lord, sanction is required for 5051, my lord.
Okay, whether a sanction was granted or not, we can ascertain the same from the record.
And next, the original records, my lord, in the records, there is no anywhere found, my lord, charge has been taken or not.
We'll examine the record.
Some interim.
Heard, mister? No, not at this instance. Let the record come. If there is no sanction, definitely we will grant the interim care. Your name, please?
FL.
Learned counsel for the petitioner, and also heard Mr. P. Thakur, learned additional counsel for the state respondent. In this petition, the petitioner has applied for Quashing, the FIR number 06 of 2029 of category PS, Kasar Silsor, corresponding to PRC case number 936 of 2023, pending before the Court of Learned Additional Chief Judicial Magistrate Kasar Silsor. Where is the petition and the documents placed on record, and also placed on record? Let notice be issued to the respondent, returnable in 4 weeks. Step upon respondent number 2 and 3 be taken by speed post and also by usual process within a week from today. However, no formal notice to the respondent number 1 since Mr. Borthakur entered appearance and received notice, but extra requisite copy of the petition will furnished for him during the course of the day. SSL call for the scan copy of the record from the Court of Learned Additional Chief Judicial Magistrate Kasar Silsor. List the matter on
On 10 September.
interim period of the petitioner will be considered on next returnable date after on receipt of record from the learned trial court.
Item 20.
Here, for section of slide A, order number 19/26, it's on page number 19. Or warrant of
Page number
19.
so how this order is illegal or arbitrary?
Your lordship, I mean, on the particular day, lordship, I was sick and I've informed the council to appear on behalf of.
Do you have enclosed any medical document here?
Yes, your lordship, it's in
Page number
21, your lordship.
21.
Relevant for-
No, warrant of arrest was issued against him on 19/3/2026.
Yes, your lordship.
Right?
Yes.
And this medical document at page number 21 indicates that he has been undergoing treatment with effect from 2/7/2026. How this medical document will help you?
Like kindly see the first line, your lordship.
Huh.
He was undergoing treatment since January 2026, your lordship. It's mentioned in the certificate.
No. Whether this will help you? Anyway, Mr. Borthakur?
Your lordship, prior to that, I've been attending the court.
Mr. Borthakur?
Yes, no, I can only. My lord. Otherwise, NIA case, my lord. Complaint case, my lord.
You can
State
then
is a
state is a
formal-
party here.
State is a formal body, my lord.
Hard miss
L once.
L.
Once.
Learned counsel for the petitioner and Mr. Borthakur learned additional support for the state respondent. In this petition under section 528 of the BNSS 2023, the petitioner has challenged the order dated 19/3/2026 passed by the learned subdivisional judicial magistrate M. Bozali Pachala in NI case number 30 of 2022. It is to be noted here that by the impugn order dated so the learned trial court has issued non-bailable warrant of arrest. Issued warrant of arrest against the present petitioner, namely Ranjit Khatunia. The learned counsel for the petitioner submits that the petitioner is an accused in NI case number 19/3 of 2026. No, sorry, 30 of 2026. And he was appearing regularly before the learned trial court in the said case. But on account of his illness, on 19/3/2026, he could not appear before the learned trial court. And he inform his counsel to take step, but no such step was taken by the counsel, for which the learned trial court has issued non-bailable warrant of arrest. Warrant of arrest against the petitioner. The learned counsel for the petitioner, referring to annexure number 3 at page number 21 of the petition, submits that the petitioner was suffering from diabetes mellitus, hypertension, chronic kidney diseases, and high uric acid level since January 2026, for which the petitioner could not appear before the learned trial court on 19/3/2026, and that the petitioner is ready to face trial, and therefore he is contented to recall the warrant of arrest issued against the petitioner and to allow the petitioner to appear before the learned trial court and to face trial. So Barthakur learned additional PP submits that the petitioner may be allowed to appear before the learned trial court and to face trial, and till his appearance before the learned trial court, the warrant of arrest issued against the petitioner may be recalled. Having heard the submission of learned counsel for both the parties, this court has carefully gone through the petition and the documents placed on record, and also perused the impugn order dated 19/3/2026. It appears that the case was pending at the stage of statement defense, and on that day the petitioner remained absent without any step for which the learned trial court has issued warrant of arrest against him. However, in view of the medical document produced before this court is of the view that a chance may be given to the petitioner to face the trial, and accordingly, this court is inclined to dispose of this petition by directing the petitioner to appear before the learned trial court on or before when the next date is fixed.
29.
On
28/9.
2026. Until then, the warrant of arrest issued against the petitioner be recalled. Sorry, not recalled, be kept in abeyance.
Indicated in a big indicate Polygon CS case number 52, section P79 411 also. And during investigation, an amount of rupees 3,67,000 and gold ornaments and 2 mobile handsets and lordship 1 water pump were seized from the residential premises of the petitioner, lordship. And after lordship full the trial, the learned Judicial Magistrate by judgment and order dated 18/12/2024 acquitted the petitioner from all the charges lodged, and also specifically observed that the prosecution failed to establish that the lordship recovered items were not stolen property, lordship. And lordship, after getting acquitted, lordship, petition before the
Chief Judicial Magistrate has acquitted you
lordship.
and rejected your Zimma petition.
Petition. After acquittal, lordship, I filed an application before the Judicial Magistrate. It was rejected. And against that order, lordship, I filed a criminal revision petition before the National Judge. It was rejected. Against that order, lordship, I
Page 10. Where is the impugn order?
Order was page 48. Start from page 48. I put it here.
Page 52, Lord, operating part, 52, paragraph 9, Lord.
Okay. Heard, Mr. I use already learned counsel for the petitioner and Mr. Bortakur for the state respondent. In this petition under section 528 of the BNS 2023, the petitioner has challenged the judgment dated 19 to 2026 passed by the learned session Judge Sribhumi in criminal revision number 04 of 2025 and thereby affirmed the order dated 3/1/2025 passed by the learned Chief Judicial Magistrate Sribhumi in GR case number 748 of 2022, rejecting the application for releasing the seized articles in the custody of the petitioner. Mr. Sorure, learned counsel for the petitioner, submits that the petitioner was an accused in GR case number 748 of 2022 under section 379 411 413 IPC. In the said case, the petitioner herein faced trial and the same culminated in acquittal of the petitioner of all the charges under section 379, 411 and 413 IPC. In the impugned judgment, no order was passed regarding the seized articles. Mr. Soduri further submits that in the judgment passed by the learned Chief Judicial Magistrate in GR case number 748 of 2022, while acquitting the present petitioner, has not passed any order in respect of disposal of the seized articles. And thereafter, the petitioner has filed one petition seeking custody of the seized articles. But the learned Chief Judicial Magistrate, by order dated 3/1/2025, has dismissed the petition filed by the petitioner. The petitioner then challenged the order dated 3/1/2025 passed by the learned Chief Judicial Magistrate in GR case number 748 of 2022 before the learned Session Judge Sribhumi by filing a criminal revision petition number 04 of 2025. But the learned Session Judge, by the impugned order dated 19 to 2026, has affirmed the order passed by the learned Session Sribhumi dated 3/1/2025. The learned counsel for the petitioner also submits that the petitioner, the prosecution side in the GR case number 748 of 2022 has failed to prove that the seized articles were of stolen articles. And in that view of the matter, the order dated 3/1/2025 passed by the learned Chief Judicial Magistrate in GR case number 748 of 2022 and the judgment dated 19 to 2026 passed by the learned Session Judge Sribhumi in criminal revision number 04 of 2025, affirming the order dated 3/1/2025 suffers from material irregularity and therefore he has contended to interfere with the same. The submission of Mr. Sudhuri needs further consideration. At this stage, a notice be issued to the respondents returnable in For X, however, no formal notice is required to be issued since Ms. Aborthakur entered a variance and received notice. But extra requisite copy of the petition will be furnished to him during the course of the day. Registrar shall call for the record from the learned trial court as well as from the learned session court and fix the matter.
15 September. Item 51.
On the other day, when you were.
My lord, yes, I have gone through, my lord, due to some technical defect, I could not get out the printout copy of those judgments. I will place it before your lordship, but before that, I would like to point out your lordship, my lord. That, my lord, if such sheet discloses, my lord, multiple offences, here one is armed act, where, my lord, prior sanction is required. Some requiring statutory sanction and others not, the entire proceedings cannot be quashed, my lord. The trial court can legally proceed with the trial for those offences, my lord, that do not require, my lord, prior sanction. And regarding those, my lord, portion of the Arms Act, my lord, that while dealing with special statutes requiring strict statutory permissions, the apex court observed that if a court discovers it took cognizance without a valid sanction, the proper course of action is not to acquit the accused or quash the entire police case. Well, instead, the court should allow the prosecution to remedy the defect by obtaining a valid sanction, because, my lord, sanction can be obtained at any stage of the, my lord, trial. So it is not that, my lord, that cannot be cured, but at any stage of the proceeding that can be cured. Regarding the Arms Act, but
No, Mr. Aborthakur, you see, the bar is that you cannot take cognizance without the sanction. But here, without sanction, cognizance is taken. Now, whether subsequent production of the sanction can validate the order.
that is the difficult, my lord. Otherwise, my lord, it is not a.
But Mr. Mune, there are several other decisions of the Supreme Court where it is stated that the ITC offences shall go on.
Yes, my lord.
ITC offences shall go on. The proceeding cannot be quashed. So,
Regarding Arms Act offences also, my lord, that can be cured, my lord. That can also be cured during.
is it?
Because, my lord, that at any stage of the proceeding, my lord, if, my lord.
No, if the court cannot take cognizance without the sanction, then
Yes.
The idea is, my lord, without sanction, if.
Then he will have.
Goes on, my lord, then is devoid of jurisdiction.
no, in respect of the Arms Act,
Yes.
offences under Arms Act, he
If the offense, there requires previous sanction and it goes on, then it is going on without jurisdiction. And jurisdiction, well, if there is no jurisdiction, then the whole proceeding becomes null and void. Now, one thing I have to see, my lord, that whether if IPC sections can be gone with or not. To the limited knowledge I have, my lord, it cannot go on, but what if it has fallen from my lordship's mouth, my lord, then there has to be some authorities, my lord. If my lord allows me some time, my lord, I will go through and submit this before the lordship.
Then your lordship may fix it some. I will also place regarding that prejudice parties also there in some of the decision I have found that yes, in my lord, in spite of cognizance also and new law also, I will have to go through, my lord. Even
But says, my lord, if the later point, if we take up this plea, suppose after framing of charge, we take up the plea of no sanction, no valid sanction, then you have to say how it is prejudicing.
and as because otherwise, my lord, that defect can be cured from the stage of cognizance. If my lord can, my lord.
okay. We will not list the matter further. We will pass the order, but by tomorrow morning you produce the relevant judgments.
Witness.
No, we will not list the matter again. What purpose will be served? If you find any decision, you submit it to the court master by tomorrow morning. We will pass the order.
Give me some, let it not be fixed on Wednesday, give me time till Wednesday morning, my lord.
Okay, Wednesday morning, clear. Okay. Okay. But we will not list the matter again. Okay. Okay.
Item 52.
Under section 87 of BNSS, and section 9, 10, 11 of the prohibition of child marriage. Now, requirement schedule is true. The annexure 5 at page 40, this is an agreement. Now she is already married to someone else, so when she left the place, victim left the place.
No, maybe, but at a relevant point of time, she was minor.
No, 17 years.
In the proceeding of special case number 22/2006, pending before the Court of Learned Special Judge Poxo Lakhimpur at North Lakhimpur in connection with FIR of Bipuri PS case number 19 of 2026 under section 87 of BNS, dated section 8 of the POXO Act, and section 9, 10, 11 of the Prohibition of Child Marriage Act 2006.
Sorry, Lordship, it should be it is not 2006, it should be 2026, Lordship.
2026.
Special case.
On the ground that the victim girl on oath before the notary public on 21/7/2026 stated that she has lodged a false case against the petitioner on the instigation of the neighbors. As on that date, she is married to one Akash Bora. Where is the petition? And registration, where is the petition, and also gone through the documents plus some record. List the matter on the first week of September. For hearing on the point of maintainability of this petition.
11 September. Coming item 9.
And video has been filed, reflecting the relevance. The people cross examination version.
So on what ground recalling of a witness is permissible?
Witnesses which intend to recall is further evidence is essential to the judge issue the case. Because of only two questions has been put forward during earlier cross examination. So
No, whether for filling up lacuna it can be allowed.
No, Lordship, but it used to be this petition.
No, no, no. The prejudice test will not be applicable here.
Lordship, the relevant only 10 question I have been
No,
mentioned in my additional affidavit and some sort suggestion, Lordship. Kindly,
it will cause serious prejudice to the other side.
Lordship,
You have already given sufficient opportunity merely because your counsel has been changed. You cannot recall the witness.
Lordship, only
This is not a court of equity. We cannot grant you.
Lordship, accused petitioner will be prejudiced, Lordship, because of in
No.
earlier cross examination due to oversight, he was in responsible.
Yes, Mortakur, is it permissible?
No, my lord. Otherwise, my lord, now he has, my lord, those, my lord, questions now he had placed before this honorable court. But those, my lord, he has not placed before the trial court. At the time, otherwise, my lord, changing of counsel cannot be a ground, my lord, for my lord. Otherwise, yes, my lord, other NIA case, my lord, definitely he would be, my lord, severely prejudiced, my lord.
If it is a case of NIA.
In case of.
Maybe.
61,000 check was, elite check was.
Maybe.
170 lakhs, 61,000 Lordship. Can we give an opportunity to further process them?
We'll pass the order. Yes, next item.
Item 45,
Please, Lord. My lord, as per occasional, my lord, the service is not completed.
Service completed,
Answer.
not completed.
My lord, fresh step.
Addressee not found. You obtain instruction in respect of the current address.
Current address, my lord, the address is same. I think it is not affected. So we take a step in both ways.
Heard Mr. Ahmed, learned counsel for the petitioner, office note dated 16/6/2026 indicates that notice issued to the sole respondent by speed post returned answered with a report. Addressee not found, RTS. Accordingly, it is provided that Mr. Ahmed, learned counsel for the petitioner, shall obtain necessary instruction in respect of the address of the respondent and shall take fresh step upon the respondent by speed post and also by usual process within a week from today. Rest shall list the matter after 4 weeks. After 4 weeks.
It definitely keep my lord after 1 month.
on 22nd September. Item 46,
I prefer the applicant to this matter of on the previous date, for mentioned that the name of the respondent number 5 has been recorded is correct. However, that is not for the case. My lords may help me at page number 30. That is the order of the learned JMFC Millard. Hearing, the respondent number 5, Mr. Ravi, that is where we have gotten the name from. So it is instructed to us when honorable board on the last date that the name may be changed by hand. So here we see that the name is the same as we find in the judgment in page number 30 and extra 2.
So you have taken a step on 13/8/2026.
Yes, the service report is already for that maybe the next date may be fixed here 2 weeks from on the second week of September.
Heard, Mr.
On behalf of M board.
Learned counsel appearing on behalf of Mr. M. Barman, learned counsel for the applicant. This application under section 5 of the Limitation Act is preferred by the applicant for condonation of delay of how many days?
Lordship, 300.
for 372 days in preferring revision, criminal revision petition against the judgment and order dated 28 to 2025. No, service report is awaited. We have not received the report.
Yes. For that, date may be second week of September.
Office note dated 13/8/2026 indicates that notice was issued by speed post on 13/8/2026 and the same is awaited. Leaves the matter on. COVID.
18 September.
Awaiting service report upon the respondent. How many respondents are there?
5.
5. Okay.
47.
Wait, please, my lord. My lord, here, my lord, I am challenging the quashing of my lord, I am challenging my lord the NI case 2534 of 25, my lord. Pending adjudication before the Court of Additional CJM Council. My lord, in this case, my lord, I had entered into an agreement with the opposite party number 2, my lord. It was a kind of a loan agreement. My lord, may kindly have page numbers.
No, notice is yet to be served.
My lord, notice to again, my lord. It has not returned, my lord. There is an office note today, my lord. May I kindly pray for the interim because, my lord, there is a arbitration clause, my lord, in the agreement between me and the opposite party number 2. In spite of that, my lord, they had, my lord, there was a security check, my lord, with them which I had given. Illegally, my lord, they have entered the amount and bounced the checks, my lord. That is my case. There is an arbitration clause also. That should have been invoked before appearing before approaching the honorable additional CJM. My lord, may kindly give me just 1 minute.
Okay, first let the notice be served. Thereafter we'll consider your prayer.
Just 1 minute to demonstrate, my lord. It is up to mine. I'll just take 1 minute of it.
No. First get the notice served. Thereafter we'll consider.
Notice served, my lord. In July only, they have not appeared till now.
Heard Mr. R.P. Sharma, learned counsel for the P.R. Sharma, learned counsel for the petitioner. Then Mr. Goswami for the respondent number 1. Office note dated 13/8/2023 indicates that NI case number 2534 of 2025 has not yet been received. And neither ID card nor unserved notice in respect of respondent number 2 has been received till date. Lays the matter after 2 weeks awaiting service report upon respondent number 2. Registry shall also issue reminder to the learned trial court for transmitting the scanned copy of the record of NI case number 2534 of 2025. List accordingly.
Final prayer for interim may be considered on the next day.
Okay.
Kindly.
Interim prayer of the petitioner will be considered on receipt of record from the learned trial court. Next.
28.
Date.
Obliged.
Next. As regards the respondent 2.
Pardon?
This is awaited.
Pardon?
For respondent is awaited.
Respondent number 2 is awaited. We have taken a step.
Yes.
Heard, Mr.
Reason
Learned counsel for the petitioner. Mr. Goswami for the respondent number 1. Office note dated 13/8/2026 indicates that service report upon respondent number 2 is awaited. List the matter after 2 weeks awaiting service report upon respondent number 2.
Once.
For very item 29.
29, 30 and 31.
arising out of same.
Yes, my lord, after 30 days, Indian custody, my lord, granted interim bail lordship. Three of them, my lord, interim bail.
You are on interim.
Lordship was subjected 36, 2026. I have been released from bail lordship.
Charge sheet submitted. Yes, submitted.
CS submitted.
Yes.
Well, but absolute
Okay,
lordship.
no. You appear before the learned trial court. What is the search sheet number?
Charge sheet number lordship 142/26 dated 28/6/26.
Probably, just, not taken.
Order dated 30/6/2026, paragraph number 1, paragraph number 2, paragraph number 3. Okay. Mr. Ahmed, learned counsel for the petitioner. No, for the accused submits that the petitioner, no, the accused is an interim bail. Person to order dated 30/6/2026, and the accused person to the said order appeared before the IO, and his statement is also recorded.
Regular bail loss, not regular bail loss. In regular, my lord, I have been released on regular bail loss as per interim order.
If you have been granted, no, you see the paragraph number 8 of the order. You are on interim bail.
Lordship.
But the regular bail was interim granted. Because case bail was not that very day. The honorable court, my lord, allowed the accused person to go on interim bail, though it was regular bail. And already they have punished the bail board, my lord, and they have allowed my lord.
No. If you were granted the regular bail, then why this matter is listed today?
Yes, my lord, the case bail was called for. Only in interim
No,
bail.
if you have been granted the regular bail, where is the question of calling the record? Sorry, case diary.
Yes, my lord. But,
You have been granted only interim bail.
so, I have paid to the he requests for the city bail account. On that ground, today's statement. And all of the orders for it, I have managed the bail order, item 30. No, till then, his bail will not.
No, you go and apply for regular bail there, and the trial court will consider the same in accordance with law.
Already they spent 1 month in jail. All the accused.
Maybe. You have been granted interim bail.
Yes. In the regular bail application,
No.
the order was interim.
No.
Kindly examine the.
My lord, what I'm submitting lordship. My lord, already bail bond was, my lord, submitted, my lord.
Maybe in connection with interim bail.
Now, my lord,
This court has not granted you regular bail.
my lord, charge sheet is submitted, not showing me, probably not showing me abscond of lordship.
Mm.
That is why, my lord, my humble submission, my lord, this bail application order may be made absolute lordship when, my lord, someone received lordship, will appear lordship.
No, interim bail shall continue. You apply for regular bail there. Follow line down.
Other accused lordship granted as civil lordship without CD lordship. Why, my lord, at the 19, may I lordship, my lord, may I have your lordship's attention in case, my lord, 19 lordship.
No, if that is your contention, then I am releasing this matter from this court.
I'm not for that lordship. My lord, then my lord, your lordship pass order. We are obliged by your lordship's order.
What are the trial court will announce?
That is my submission before this order.
No, my question is whether you appeared before the IO or not. Person to the appeared, and his statement is recorded. And on such count, he has contended to make the interim order dated 30/6/2026 absolute in the same terms and condition. Per contra, Mr. Goswami learned additional PP submits that he has received the case diary. No, he has not received the case diary, though the case diary was called for by order dated 30/6/2026. And as per his instruction, the IO has completed investigation in the meantime and submitted charge sheet before the learned trial court, being charge sheet number 142 of 2026, dated 28/6/2026. In view of the submission of learned counsel for both the parties, this court is inclined to dispose of this petition by directing the accused to appear before the learned trial court and to apply for regular bail on or before.
Second September.
And in the event of filing such an application, the learned trial court shall consider the same in accordance with law. Till then, the interim order, till then, the privilege of interim bail granted by the order dated 30/6/2026 shall continue. Same order in other two matters also.
Pilot sound. Long time maybe. One month.
To appear.
Huh?
On 16th September,
Lost. All right.
item 32.
31. It's 31. Interim order date 7.
Okay, we'll see.
32.
Make video. The last decision, scan of the tax was called for.
That is reciprocal.
Receipt.
Except the.
Whatever the CD
possession
receipt.
materials.
Otherwise, my lord, at the time of my lord seizure of those kettles, at that point, they my lord failed to produce any document. And now in this petition, my lord, they have submitted annex all these documents or genuine of these. They have not produced all these documents before.
No, that's all right. But what is the stage of investigation?
Yes, my lord.
What is the stage of investigation?
Investigation, my lord, otherwise substantially progressed. My lord.
Progress. So further custodial detention, whether required in the interest of investigation or not. May not be. Okay. We'll pass the order.
4% minor.
We'll pass the order.
Item 36.
Yes. 483 application, my lord. 20 days in.
20?
20 days.
20 days.
Section of my lord, immoral traffic and detention act, my lord. Your FR is page, my lord, 14.
Case diary was called for?
Case they received, my lord.
Test 12, my lord. English translate.
Case 12.
Yes. May I read, my lord?
Not necessary.
Result list is my lord, page 16, my lord. Result. Page 16, my lord. The article says by one SI, the deposit question of my lord. There is a my lord procedural lapse. As per this act, my lord.
No. Investigation has to be carried out by DSP level
Yes.
officer or inspector.
Yes, my lord, the inspector, here, my lord, IO is my lord DSP, my lord.
Yes, my lord. But my lord.
But
says, my
initial,
lord,
that is my lord, during my lord preliminary, my lord inquiry, that seizure, at the time of seizure list. Sub-inspector.
Yes.
Later on, my
That
lord,
is not my lord permission. As per section 15, my lord.
No, that is before rescission of the FIR.
Oh my god.
The seizure was carried out before rescission of the FIR. So after registration of the FIR, investigation is now carried out by the DSP level officer. So what wrong with that?
My lord, as per this, my lord, and my lord, asked by the deputy, my lord, superintendent of police, or my lord, special officer, my lord, who was appointed, my lord. As per this act, my lord, section 15, my lord.
Mm.
Can I read? My lord?
Mm.
Search without warrant, notwithstanding anything contained in any other law for the time being imposed whenever the special police officer or the trafficking police officer, as the case may be, has reasonable grounds for believing that an offence punishable under this act has been or is being committed in respect of a living in any premises, and that such of premises which warrant cannot be made without undue delay. Such officer may, after recording the grounds of his belief and search such premises without a warrant. There is a provision, my lord. Here, my lord, as per FIR, my lord, one Bajrang Dogs, my lord, search, my lord, my premises, my lord.
Mm.
As per in FIR, my lord.
Mm.
They have, my lord, who knows they have kept these articles, my lord. After, my lord, here,
No,
my
this,
lord,
no.
and two, my lord, section 15(2), my lord. Here it is. For making a search under subsection 1, the special police officer shall call upon two or more respectable inhabitants, at least one of whom shall be a woman, of the locality in which the place to be searched is situated, to attend and witness the search. And
No, Mr. Kolita, you see the question you have raised at this stage cannot be considered. That is a subject matter of trial.
yes, my lord. But my lord, as per my lord, case diary, my lord,
Hmm.
is there this lacuna? Yes or not? Yes. It is the case. There is, my lord, one judgment of petition court. Para 20, my lord. Para 20.
Yes.
Eight also by special police officer. Here, my lord, rate by on Bajrang party, my lord.
Yes, what is there in the CD, Mr. Gautam?
My lord, statement of the victim girl is available in the city, and regarding his submission that my lord Bajrang Dol has raided the my lord that spy and salon, that is absolutely wrong, my lord. On the basis of that information, my lord, police team was constituted. Police team has searched and raided that spy and salon, my lord. That information was initially provided by Tokas Chaudhary. He is the member of the one trustee of Bajrang Dol, my lord. Police team was constituted. Thereafter, my lord, police team, my lord, raided and searched and raided the time. Otherwise, my lord, from the victim statement of the victim, your lordship may kindly tell 183 and 180 BNS, my lord. Age of the victim is 21 years, my lord. 183 and my lord 180 BNS is content somewhat, my lord. Only my lord victims 183 and 180. Oh. No. In her 183 statement, my lord, she has not implicated the accused person, but 180 BNS. Same.
Okay, we'll see and pass the order.
Item 7, dealing with item number first.
Lordship, this case arise out of similar FIR, Lordship. Lordship, what happened in this case, Lordship, is search which was made. Search is the, as per my humble understanding, my lord, search is the very basis of the this case, because Lordship, if search is not done as per law, then the FIR trial in the trial also maybe get acquitted. So what happened, Lordship, is as per section 15, Lordship.
No, we are not in trial now.
Yes, Lordship, pardon, Lordship, our Lordship. as per section 15 lordship, the search has to be made by the special police of the lordship. It is clearly mentioned lordship. And another thing lordship, search cannot be, can be made without warrant, but the reason has to be recorded as per section 15 clause 1 lordship. So another thing lordship, during the search lordship, two respective witness has to be there, and one has to be a women lordship. But as per Seizure, it is on all three are male lordship. So that is their lordship. And another thing lordship, notice was not served lordship as per section 35 of BNSS lordship. That is also there. But another thing lordship, this search was made by private group lordship, so which can be seen from the FIR lordship.
No. Subsequently, search was conducted by police.
The police
Yes,
lordship,
madam, I have star marked those by the OC, my lord, and petition was handed over to the DSP.
lordship, who signed this? Who was the signer of the lordship? In the aspect 17 of my petition lordship, below lordship may be seen lordship who signed the deposit SI. It is not specifically said. And another thing lordship,
No, when DSP was endorsed to investigate the same.
no, lordship. Search was made on 28 lordship.
Which provision you have submitted and not to be complied with?
Lordship,
Which of the provision the IO has not complied with?
lordship, section 15 lordship. 16 for the.
No, BNS.
BNS have
BNSS.
35 lordship. 35 3 lordship.
35.
I have only he has a reason that is not satisfactory reason lordship. Yes, 20 may be seen lordship forwarding report lordship.
No,
Lordship,
whether
you have-
any prejudice is caused to you.
Yes, lordship, I am reading lordship. The notice under section 35(3) of Bharatiya Nagara
No.
Why not serve lordship? Only the apprehension of the police that I pay. There is reasonable grounds to believe that if given prior notice instead of being arrested, they would have altered the owner of the spa lordship. That is not satisfactory explanation as per my humble submission lordship. The notice has to be served lordship, and the FIR registered on 29 and seize was made on 28 lordship. That was also after seize made by the private group lordship. The may I read lordship FIR?
No. Private group has not seized anything.
Lordship.
Private group has not seized anything. It was seized by police. Sorry.
Lordship, they have private group entered the premises lordship.
They have detected and they have reported the matter to police and police apprehended them.
No, lordship, they have entered the premises of the Ceylon lordship. As per FIR lordship.
Yes.
Yeah, then they handed over to the police.
No, they informed the police and police came and apprehended the boys and girls.
Lordship, may I read the vernacular lordship?
No, not necessary.
Police, before.
Okay, your contention is that 35(3) has not been complied with.
Yes, lordship, that is their lordship.
Okay.
And seizure was not made by the
Okay.
special.
Bhartagur, hand over the case there.
Yes, sir.
Okay.
Offline.
55 coagulation.
Report was called for regarding the Zimbabwe vehicle. Zimbabwe capital.
You have received the report.
Yes, Lordship. As per the report, Lordship, in view of the facts and circumstances stated above, it is most respectfully prayed that this honorable court may kindly be pleased not to release the vehicle and may kindly allow the said vehicle to remain in the custody of the investigating agency till the completion of the investigation and the disposal of the case.
Why it was seized?
28/6/2026.
No. Why the vehicle was seized?
Because your lordship, the vehicle has been transported the cattle, your lordship. In a report, it is also stated on the arrival of the complainant or the staff and opponent for charge of the vehicle conducted in the presence of independent witness, a total 10 cups were found being transported illegally, concealed beneath bags containing disposable of plates and glasses with their heads and legs tied in a cruel manner.
It is there, but you have to establish the search during trial.
Yes, sir.
What purpose will be served by keeping the vehicle?
Lordship.
What is the stage of investigation?
Not charge sheet, not yet submitted, Lordship.
Not yet submitted.
Not yet.
Investigation is completed or not completed? When the vehicle was seized?
28/6/2026. Almost 49 days.
Hmm?
2 days, almost 49 days.
Itu preservation ni. Investigation almost completed or not completed? Almost completed.
In case of the at least statement of the accusers be taken.
Then you say subsection 5 to section 11 of the Cattle Preservation Act. The magistrate may release the vehicle on furnishing bank guarantee. What is the value of the vehicle?
Around it will be 6.8 up to 9.62.
Is the insurance certificate available with you?
No, Lordship, as per Google, I have searched.
When it was purchased?
It was purchased.
Date of
Date of registration, Your Lordship, 18 April 2026.
Vehicle.
Yes. And that vehicle has been with the loan with HDFC Bank. HDFC Bank. And Your Lordship has been decided similar situated matter. I have ordered.
No, that's all right, but
And as per the Sundarbai Ambalal Desai and Your Lordship order, the Lanet Trial Court bill has been complied with that.
is the insurance certificate available with you? Can you produce it?
Not annex, Your Lordship.
No, not annexed that, all right. Do you have the copy with you?
I have not, honor will be with it.
Can you produce it by tomorrow? We'll pass the order tomorrow. We'll not list it. You obtain the copy,
Okay.
furnish it to the court master.
Matter will not list. Okay, matter will not list in cause this.
Oh, will not be listed tomorrow.
Okay, okay.
We'll pass the order on today's date.
All, Lordship. I will be provided. Part of record. If possible today, I will be provided. Declare.
Item from production list. Item 1, civil petition 1151 of 26.
May I have your lordship? Lordship, the state has preferred this appeal challenging two orders finals. Order dated 4/8/2026, order dated 14/8/2026. As the events unfolded, my lords, elephant was caught by police apprehended by police along with two persons.
None of these orders are legible.
My lords, I have typed copies, type those copies, my lords. First order is of 1/7/26. The sole respondent approaches the CJM, my lords, and admits that he doesn't have any document in his name which establishes him as the owner or the registration holder, my lords. Then that lordship was founded at page 14. Then that page 14, my lords, that order, the forest department was asked to, my lords, provide a status report, which we accordingly provided, my lords. And then, my lords, at page 18, the Zimma petition is again heard and rejected. And the basic foundational order is at page 21, my lords. Type copies. While adjudicating this petition, my lords, we are not put to notice. Whereas, my lords, the ground taken by the sole respondent was that the health condition of the petitioner, of the elephant, has deteriorated. And that very aspect, my lord, that elephant, there cannot be any sale of elephant, my lord. No purchase and sale, which is admitted, my lord, clearly.
So originally, certificate was issued in the name of one Leela Phukar.
Nila Phukar, my lords. And he admits that he doesn't possess any certificate. And because, my lord, by operation of section 43, my lords, of the Wildlife Protection Act, there cannot be any sale or purchase. That apart, my lords, that elephant was recovered at Gauhati. It is in custody in Halwating. The ground taken by the respondent was that it is devastated by flood, so the elephant could not be treated properly. Whereas, my lord, we hold medical documents, even this also, but it is the updated. This is from the state veterinary dispensary at Amguri. The elephant is in good health. It's 16th, my lord. And if my lord takes up the act itself, my lord. Wildlife Protection Act. 43, my lords. Forty-three completely bars, my lord, any kind of transactions. Here in page 23 type copy, it is admitted by the respondent that he bought it on sale.
No, Mr. Gogo, you see this section. You were referring to section
43,
43.
my lord.
43 is inserted by the Act of 2003,
My lords.
and the elephant was sold in the year 2000.
No, my lord, it's 2000. There's a slight error in the copy, error in the, my lord, say the translation. It's sold in 2009. That apart, my lords, my lord will kindly come to section 57. Section 57 is a presumption, my lords. My lord is correct, my lord. It is 2000. My lord is correct. It's 2000.
So at that time, there was no bar
but
in
my
selling
lord,
or
that
purchasing.
Then also, my lord, 57 was there.
57, that is
57 presumption is there, my lord.
No, here the
My lord,
prosecution has
no, my
not
lord. Then
started.
regarding
will
that
be
also, my lords,
applicable in
my
prosecution.
lord, my lord will kindly see page 14.
Hmm.
Page 14, my lord, the past order.
Hmm.
And page 15 there on, my lords. Learned counsel for the petitioner fairly submits that the elephant is presently not registered in the name of the petitioner and that no document has been produced to show that the registration certificate has been duly transferred, renewed, or is presently valid.
And that's all right. He purchased it as per an agreement dated 29/6/2000.
My lords. Now that is also under dispute because we have provided a specific my lord, at page 18, lords, you will see the in charge seizure, my lords, takes note of those things, my lords.
Let the scan copy of the record come.
My lords. My lord, let it be stated, my lord.
No, to
We
grant
have not
any
handed over the
stay,
elephant, my lord.
whether it can be said that any prima facie case is made out or not.
My lords. Well, till then, my lords, because my lords, what has happened, my lord, will see the conduct, my lords.
Conduct means?
Conduct of the, my lords, I will name those, my lords. Is issuing show causes like the today itself the matter was fixed, my lords. And the learned CGM wants the whatever order is passed by tomorrow. Because the matter was fixed initially on 3 September. We had enough time, my lords.
No, this
And
focus
that, my lord,
notice
and
is
that
not.
health issue,
No, no.
that is the second Zimma petition.
Mr.
We
Gogoi,
should have been put to notice. and the learned court should have asked for a status report. Which is clearly reflected, my
No,
lord.
no, Mr. Gogoi, in this petition, you are not challenging this so cause notice.
I'm not on that, my lord.
This notice is not challenged here.
No, I'm not challenging, my lord, but entire edifice of that notice is that those orders of 4.8 and 14.8.
Mm.
Second Zimma petition, we are not put to notice. The petitioner comes in, the respondent therein, my lord, the Zimma petitioner comes in, says the elephant is
Alright.
not receiving any
Mr.
treatment. We
Gogoi,
could have,
Learned.
we should have been put to notice, my lord, because I have presented the now status report also. The elephant is doing well.
Special PP Wildlife Forest Assam. For the petitioner, no, for the petitioner. In this petition under section 528 of the BNSS 2023, the petitioner has challenged the order dated 4/8/2026 and 14/8/2026 passed by the learned Chief Judicial Magistrate Shivsagar in SIV/WLO/01 of 2026 -2027. 2027. Full stop. It is to be noted here that by impugn orders dated so and so, the learned Chief Judicial Magistrate Shivsagar has allowed the interim Zimma of a seized female elephant, namely Junmani, to the opposite party, namely Ratneswar Gogoi. Here is the petition and the documents placed on record. And also peruse the impugn orders dated 4/8/2026 and 4/8/2026. Having heard the submission of Mr. Gogoi, learned special PP for the state of Assam, this court is of the view that in order to adjudicate the issue raised in this petition, perusal of the case record is found to be necessary, and accordingly it is provided that registrar shall call for the scanned copy of the record fixing the matter on
24,
24th. Sort of.
20,
No,
21. Short it. 24 August,
28th.
24,
20.
24, 24 August,
Okay.
coming Monday.
Till then, the impugn orders dated 4/8/2026 and 14/8/2026 be in the interim, the order dated so and so stands state till next day.
Obliged.
Item 56.
No, please, your lordship, the intermediate quantity lordship, the sachet was submitted lordship, the TCR is the receipt lordship, today is 64 days lordship. The length of pretension lordship, the which has the trial.
64 days.
64 days. Intermediate quantity lordship, the 84 grams of suspected heroin.
Yes, Vishnu.
Lordship, recovery as from their possession, lordship.
Lordship, the case 14 lordship, the brief of the case lordship. Case 14 lordship, the 84 grams without cover is stripped to the body of career accused Vice Asmina Parveen, wife of Ainar. 84 grams.
Charge submitted on 21/7/26. Section 21B and 29 NDPS.
With the charge is framed.
Not framed.
No,
yet, but
lordship.
the last date was gone, it was 11/8/26 for production, APN production.
Any condition, lordship. Here's the trial lordship. Intermediate control. Today 64 days.
Heard Mr.
Yeah, no,
Learned counsel for the accused and also heard Mr. Usami learned additional PP for the state respondent. This application under section 483 of the BNSS 2023 is preferred by accused. Asmina Parvin, Maherun Nesa Khatun, and Somez Ali, who are languishing in jail azut in connection with North Gauhati PS case number 61 of 2026. Corresponding GR number 465 within bracket K stroke 2026. Under section 21B stroke 29 NDPS Act. Since 15/6/2026 for grant of bail. It is to be noted here that above noted case has been registered on the basis of an FIR lost by one. Sakriti Doemari, SI of Police, Polasbury PS on 15/6/2026. The allegation against the essence of allegation in the FIR dated so and so is that on 15/6/2026 at about 7:15 AM. One Asmina Parvin and Madam Nessa and one Somez Ali are found traveling in a traveler bearing registration number AL01KC 0971. And while the vehicle was checked at Amingao at about 11:15 AM, 6 numbers of soap boxes, struck packets of heroin weighing 84 grams were recovered from the possession of Asmina Parvin.
Final.
The learned counsel for the accused submits that the accused were arrested on 15/6/2026 and forwarded to the jail azut on 16/6/2026. And for last 64 days, they are behind the bar. The learned counsel for the accused further submits that in the meantime, investigation of the case has already been completed and the IO has laid charge sheet against the present accused person. And that the quantity of contraband substances allegedly recovered from their possession is of intermediate quantity. And now the trial will start and they will appear before the learned trial court on his and every date, and therefore Mr. Ahmed, learned counsel for the accused, has contended to enlarge them on bail. Mr. Goswami, on the other hand, has opposed the petition. He submits that charge sheet has already been submitted against all the 3 accused persons, and the charge is yet to be framed. But having heard the submission of learned counsel for both the parties, this court has carefully gone to the petition and the documents as on record and also perused the case record. A scanned copy of the record received from the learned trial court. It appears that investigation has already been completed and charge sheet has been laid before the learned trial court. However, charges are yet to be framed. And it also appears that the quantity of contraband substance allegedly recovered from the possession of the accused Asmina Parvin was of 84 grams, which is of intermediate quantity. And since search sheet has been submitted in this method, the question of influencing the witnesses or hampering the investigation does not arise. Then under the given facts and circumstances, their further custodial detention seems to be unwarranted in the interest of investigation, and accordingly this court is inclined to allow this petition. It is provided that on furnishing a bond of rupees 25,000 is with one curative likened to the satisfaction of the learned special judge NDPS Kamrup Amingao, the accused persons being Lerzon Bay.
Diploma.
May it please your lordship. Lordship kindly take the matter after some time.
Why?
Lordship, my senior is on lake.
Who is your senior?
He is on another SP Choudhury.
Forty-one,
We are on interim and we have recorded our statement.
They must granted to her. It is nice that he has appearance and recorded. The owner of the cattle ship. Barney Super Lordship.
Hartmess,
He bore a lordship.
learned counsel for the accused, no, for the applicants, and Mr. Goswami for the respondents. This application under section 482 of the BNSS 2023 is prepared by applicant. Obid Pal,
Yes, lordship.
who has been apprehending arrest in connection with Borkola Peace case number 01 of 2026 under section 61 within bracket 2, 112 within bracket 2, 303 within bracket 2, 317 within bracket 4, and 318 within bracket 2 of the BNS reduced section 59 of the Food Safety and Standard Act 2006. Notably, above noted case has been registered on the basis of one FIR lodged by one. Who lodged the FIR?
Lordship, SI Moniram Kolida of Warkhala PS.
On the basis of an FIR lodged by Monizam Kolita, SI of Police Borkhala PS Kasar, District Kasar on 9/1/2026. The essence of allegation in the FIR dated so is that uh, 240 Where is the seizure list?
Lordship, it is at page 23, annexure C.
In connection with Borkala PSGD entry number 9 of 9/1/2026. Hundred and 33 bags of suspected Burmese supari were recovered from a vehicle bearing registration number.
No, Lordship, the 133 numbers of bags were recovered from Badarpur Railway Junction. Those are the
No,
articles.
no,
of
it is
petition.
initially how many bags were recovered from the vehicle?
From the vehicle, 57 bags and another 240 bags. 57, 240 and 28. Page 3, paragraph 2, Lordship.
Where is the seizure list in connection with this FIR?
That is what, Lordship. Those items were recovered from the vehicle.
No, no, where is the seizure list?
With regards to the articles seized from the
Vehicle.
petitioner- vehicle seizure list is not there, Lordship. The seizure list of the petitioner's articles are annexed.
No, no, I am asking about the seizure list of the articles mentioned in the FIR.
That is not there, Lordship. Those articles are
Okay,
not the petitioners.
57 numbers of gunny bag containing suspected Burmese supari were recovered from a vehicle bearing number AS11-3-3203, which will make it Venu car, and 240 numbers of gunny bags of suspected Burmese supari were recovered from another vehicle bearing number RC JK02-CJ5990. From the position of one Kulbinder Kumar and Zunab Ali Barbuya. Learned counsel for the applicant submits that the applicant was granted the privilege of interim periodic bail by order dated 26/6/2026 in person to the said order. The applicant had appeared before the IO and he has been cooperating with the investigating agency. And his statement is also recorded, and therefore he is contented to make the interim order dated 26/6/2026 absolute in the same terms and conditions. Per contra, Mr. Goswami, learned additional PP has produced the case diary before this court and he submits that the applicant has been cooperating with the investigating agency. So whether his custodial interrogation is required or not?
Yes, he appeared as separate record also, and Zimma was given, Zimma was given to him, Lordship. So at this stage.
And further, Mr. Goswami submits that since the applicant has been cooperating with the investigating agency, his custodial interrogation is not required in the interest of investigation. Accordingly, taking note of the submission of learned counsel for both the parties and also considering the materials collected so far in the case area, and further considering the cooperation being extended by the applicant with the investigating agency, his custodial interrogation seems to be unwarranted here in this case, and accordingly, this court is inclined to dispose of this application by making the interim order dated so and so absolute in the same terms and conditions.
42.
Deeply obliged, Your Worship.
We have not received the
It is.
case diary, not received yet.
Hard miss,
Vidas.
learned counsel for the applicant.
Same.
Mr. Goswami learned additional quickly submits that he has not received the case diary. Accordingly, last opportunity is afforded to Mr. Goswami to produce the case diary before this court on
24th.
24th. 24th.
43.
43 is same lordship, 42 and 43 is. I think on the same, yes.
43 Lordship. There's an interim in 43 Lordship.
Okay, interim order in 43. Past earlier shall continue.
On 3rd September. 44.
My pleasure, Lordship. Lordship, pre-arrest bail application, Lordship. I'm not on interim, and case diary was called for.
Yes, sir, received, my lord, but my lord, medical report not received. It is registered under my lord 118(2), previous art. PM report not. Yes, sir.
Lordship, may kindly come to the FIR once, Lordship.
The
Yes.
case is registered under section
118 is there.
1182 is there, my lord.
Hmm.
Subsection 2, there is previous art.
Is there a medical document?
Legal document, nothing, man.
Then
And previously it was not called for. Pardon, my lord. It may be
This is the
called
first
for.
time the case diary.
Yes, ma'am.
no, that's all right. The medical report is available there.
No, ma'am.
That is not available.
That is not available. So it may be called for, my lord.
It's a sorted then.
Well,
Pardon,
Lordship,
sir?
until then, Lordship, petitioner may be protected, Lordship.
Maybe, but
Some interim protection may be given. These are the local person. Actually, the backdrop of the case is that, Lordship, some people, along with a local organization, it may be there in the case diary also. They went to the institution of the complainant, which is Lordship, an institution of Oil India Limited, and many people gathered to raise issue of local employment. Thereafter, some persons were detained. I have annexed the forwarding report. And these two petitioners went to the police station to meet the person who were detained at that time. As a backdrop, when they went to the police station, these petitioners are also named in the FIR. But Lordship, actual fact is that once the medical report also come, it will be revealed that there is nothing, no injury. And also, Lordship, 140 does not attract in this case. And Lordship, other thing is that the complainant claims to that this one chain has been snatched, but that particular, Lordship, offense is not will not attract to us because
okay, let us fix a very short date. In the event of failing to produce the injury report on that day,
my lord.
who will consider the prayer?
And my lord, 25th, my lord. Next week, 25th.
No,
25th will be long enough.
or that this week.
And my lord,
Heard, Mr. Your name?
D Medhi, Lordship.
D. Mehdi, learned counsel for the applicant, and Mr. Sarma, learned additional PP for the state respondent. Mr. Sarma submits that he has received the case diary, but the injury report of the victim is not available in the case diary. And since the case is registered under section 118 within bracket 2 of the BNSS 2023 also, BNS 2023 also, the perusal of the injury report is very much necessary, and therefore is contented to grant him some time to produce the same. They are allowed, list the matter on Friday.
Lordship, it may be reflected, Lordship.
Friday.
It
In
may
the
be
event of
reflected.
failing to produce the injury report to the victim on that day, the court will proceed to examine the CD on that day and will dispose of the bail application on the basis of materials available therein.
Deeply obliged, Lordship.
Item 38.
Yeah, please, the lordship. It's a charge sheeted case, lordship, and in the last occasion, the TCR was called for. And in this particular FIR, lordship, find it page number 16. The allegation is that on last 18/8/2025, here at around 9 AM in the morning, my minor sister, aged about 17+ years, fair complexion, height around 5 feet, wearing school uniforms, I had left the school but did not return despite extensive searching. She could not be traced, and as such, taking the course of law, it is
Item 23.
that observation is there, no, lordship, within a week, you will appear.
Within
before
a
the-
week, within a week.
May I please, your lordship? Lordship, in this petition, my lord, in the last occasion, CD was called for, my lord.
Lordship, I've gone through the records, but the TCR doesn't contain the CD.
Okay.
Lordship, on the last occasion also my.
Otherwise, my lord, there
Lalitas
is
paid
nothing
for it.
against me in the
Let
FIR
me
also.
come, your
It's a-
lordship. Why they're not
FIR
sending
itself,
it?
there is nothing, nothing has been seized from me. The allegation of 380 theft, my lord, against my son, my lord.
23.
And only because I have pursued while the police was harassing my lord, I have taken bail. Therefore, my name has been put in the column of the sending accused names for trial. This is the only thing, my lord. Otherwise, nothing, I am no way involved, not a single word in the FIR against me, my lord. And that is also the pending of the.
No,
Barnett
yeah,
court,
no,
my lord.
no. Mr. Sonda, you see, there may not be any incriminating materials in the FIR against you, but we have to examine the statement of the witnesses.
Lordship,
Those statements are right now not available on the record.
lordship.
Let it come from the trial court. We'll
From
fix it
Friday,
for
my
that.
lord, it is just from SDGM to Kamrup Metro, my lord.
Okay, all right. Friday.
Friday, my lord. Yes.
Heard Mr. Sonda, learned counsel for the petitioner, and also heard Ms. Bhuya, learned additional PP cum senior advocate assisted by Ms. So-and-so. Ms. Bhuya submits that though the scanned copy of the record has been received, yet the case diary part is not available in the said record. And she submits that in order to dispose of this petition, perusal of the statement of the witnesses which are available in the case diary is necessary. And therefore, she is contented to call for the scanned copy of the case diary from the learned trial court. They are allowed. List the matter on
21st minute.
CD.
21st.
21st minute.
Friday.
Friday.
Okay, okay.
Obliged diplomas.
Mr. Dasper, respondent number 2.
Interestingly, my lord, in this case, after getting notice by the informant, she is also not appeared in this case, my lord.
Okay.
Notice also served to her, my lord.
I was gonna say.
And he is.
Item 26.
Lordship, the learned counsel is engaged on another matter, so kindly the matter may be listed on Wednesday.
Okay. Wednesday possible? When? Next week.
Lordship, there is an urgency in the matter.
Urgency, that's all right. We are ready to hear the matter, but if you are not available, then Monday, next Monday. On the pair being made by Miss
S. Das.
Learned Counsel appearing on behalf of Mr.
Lal.
Lal, learned counsel for the petitioner, and this matter is since adjourned to be listed on Monday.
Oblige, Your
28 August. Item 27.
May it please your lordship. Your lordship, here, the trial court had issued a non-bailable warrant against me while I was working in Kerala, your lordship. In a similar matter, lordship has already granted the accused petitioner liberty to appear before the trial court on 28th of August, your lordship.
You're not non-bailable warrant, then thereafter PNS
PNS.
issued
I have attached.
on
the order in-
11/2/2026, my lord. As regards other two accused charges were framed, your lordship, on 13/3/2026.
Should I kindly peruse the order on page number 13, your lordship? 13, page number 13 is the order. Page number 13, your lordship. May I read the second part, your lordship? It says, PNA issued against him is returned with report stating that here he could not be traced out at the address mentioned in the charge sheet, your lordship. We have mentioned it in our averments that he was working in Kerala after he received bail and the summons or everything which were delivered, your lordship, and thereafter the BWA notices he did not get, your lordship. Now he has come back to Assam, your lordship, and he is ready to face the trial, your lordship.
Let him appear, your
will
lordship, on a fixed date, but no protection be given to him.
Lordship, moreover, your lordship, same accused petitioner in criminal petition number 1082, there were in the same court, your lordship, has already granted him protection and asked him to appear on the 28th of this month. He's ready to appear.
So when this case is fixed,
This case is not fixed against him, your lordship. It is kept in abeyance, your lordship. Against this.
no,
accused petitioner.
maybe. But
Instant case,
proceeding
instant
is
trial, my
going
lord.
on.
I have gone through an order dated 16/7/2026.
Mm.
No witnesses present, no witnesses turned up, issue fresh summons. Next date, I did not record it. I'm sorry.
Okay, let him appear before
Yes.
the court. Heard, Mr.
TL Oscar.
Learned counsel for the petitioner and Ms. Devonia, learned senior counsel, additional PP for the assisted by Ms. Windsor for the state respondent. In this petition under section 528 of the BNSS 2023, the petitioner has challenged the order dated 11/2/2026 passed by the learned subdivisional judicial magistrate as Baksa. Mosolpur in PRC case number 509 of 2023 arising out of Goresar PS case number 117 of 2023. Is to be noted here that by the impugn order dated so the learned subdivisional judicial magistrate as Baksa has issued a standing warrant of arrest for non-appearance of the petitioner. The learned counsel for the petitioner submits that the petitioner was earlier granted bail in the aforementioned case. And thereafter, the petitioner proceeded to Kerala for his livelihood. And thereafter, he returned home and came to know about the pendency of the present case. And that he is ready to face trial, and he therefore contented to recall the warrant of arrest issued against him and to allow him to participate in the trial. As Voya learned additional PP submits that a date may be fixed for appearance of the petitioner before the learned trial court. However, she submits that no interim protection may be extended to the applicant. Extended to the petitioner. Further, having heard the submission of learned counsel for the petitioner, This court has carefully gone through the petition and the documents as in record and also perused the impugn order dated 11/2/2026. It appears that by aforementioned order, the learned trial court, based on the report of PNA issued against the petitioner, has kept the matter file and issued a standing warrant against the petitioner. But having heard the submission of learned counsel for both the parties and also considering the facts and circumstances on the record, this court is inclined to dispose of this petition by directing the petitioner to appear before the learned trial court on or before
7 September.
Your Lordship, we are appearing tomorrow, Your Lordship. Within 2 days, it will be enough, Your Lordship. We are ready to appear tomorrow, Your Lordship. By
The
20,
order has to be communicated.
by 20th of August, Your Lordship.
28th of August.
By then.
Okay, 21st of August. And to apply for regular bail, and in the event of filing such an application, the learned trial court shall consider the same in accordance with law. Till then, the standing warrant issued against the present petitioner shall be kept in abeyance.
Deeply.
Item 53.
Lordship, the learned counsel is on the way, so kindly allow the matter to be heard. For item number 26,
No, already we have dictated the order.
May it please, your Lordship. Lordship, this is an NIA proceeding and your Lordship, they have taken a ground that there was delay of 7 days and only 2 days delay was condoned, so cognizance order was made, Lordship. There is a jurisdictional error. After passing of 143A interim compensation, Lordship. Lordship, I have gone through the condonation application, though it was not annexed with this petition, Lordship. There I found that the complainant explained the delay of 2 days in paragraph 12 and 13, Lordship. Mainly on 13, the complainant begs to state that the demand notice dated
No,
23.
where is the petition?
Lordship, that was not annexed by the petitioner along with this petition. Condonation, whether any objection was filed to this application, that is also we are not sure, Lordship. Objection filed to this petition or against it. Our condonation application.
Without noticing as cognizance was taken.
Delay condonation?
Delay condemnation, court has not noticed, the court has taken the cognizance without noticing us. Lordship, the case is very much clear. There are admittedly 7 days delay to file the case. The condemnation of delay was spread for 2 days. And 2 days has been condemned. 5 cases still remain, Lordship. This is admitted, I think.
In our calculation, Lordship, there is a 5 days delay from 10. The cause of action arose on 10.
No, that's all right. Whatever be the delay, the court has, learned court has condoned the delay of only 2 days.
2 days, Lordship.
Even then, if we accept your argument that there was delay of 5 days, then 3 days remain not condoned.
Lordship, that 3-day 2022 calendar I have gone through. 3 days were holidays, Lordship. Second Saturday, Sunday, and 15th August, Lordship. This is 2022 calendar, Lordship. So why the 2 days delay was filed, I have asked the engaged counsel who drafted this petition. Then he said that there were 3 days holiday. Then immediately on 16th we have filed. So normally, Lordship, in this case, only 2 days delay.
Lordship, as per the paragraph number 12 of the complaint petition,
The cause of action arose on 10/8/22.
Mm.
Sorry, infant,
10/8,
sorry,
10/8.
10/8/22. And this complaint petition has been filed on 16/8.
Then lordship
On
will find.
16/8. 6 days here.
No, lordship kindly say 10/8 will be excluded. There are decisions of Honorable Supreme Court that the cause of action date to be excluded, lordship, from the counting of period of limitation.
Mm.
Then will come 11 and 12, lordship. Both were, those were not holidays, lordship. Then 13, your lordship will find second Saturday.
Mm.
14 is lordship Sunday. And 15th August was a holiday, lordship. Then thereafter on 16th August, the petition was filed. So he explained that there were 2 days delay only.
Okay. You bring on record the application, we will see.
Lordship, it is to be
Lordship, even
brought
though I
on
have a-
record by the petitioner, lordship, this petitioner. If your lordship permit me, then I can file an,
I have the certified copy of the.
because they
cognizant-
have taken a ground that there is a delay, so it is their duty to bring
No,
an.
that's all right. That is their duty.
Lordship, I have the certified copy of the cognizance order. Now I have seen that the delay was condoned only 1 day by the learned magistrate. That is certified copy, Lordship. Yes.
Date to sign, phone to date of policy.
আরো একটা কপি কত অরিজিনালটা কত
Order to assign.
that is on 25 page
25 vehicle. Okay, 2022.
Only 1 day was condoned.
1 day condoned. Even though 2 days period condoned 1 day.
Our prayer was for 2 days, lordship. The delay was condoned for 1 day. That was mistake committed by the trial court, lordship. There was no mistake on the part of the complainant, lordship. As because lordship, so motor writ petition, that was taken into consideration.
That was withdrawn, Lordship, before filing. That was withdrawn on March. This judgment I have also available.
That was up to
Suomoto case has
28
already been withdrawn
28
on March, and this case was filed on August. That extension of limitation period
No, Lordship.
judgment on the Honorable Supreme Court has been withdrawn on the March 2022.
No, it was still substituting as per
No,
that
no, no.
so moto condonation, lordship, up to 28/2/2022 condonation
Yes.
was already, lordship, exempted. The delay period was exempted by the Supreme Courts from 15/3/2020 to 28/2/2022. And thereafter, lordship, 3 months extension period was given by the learned Supreme Court, lordship.
No, that judgment I have. Two. Full judgment to. দুটো দিলাম।
Oh, April to this 25, 28, 0.
Let us do one thing. You produce the, you bring on record the application file before the trial court for condonation of delay.
LCR may be called for. Then everything
LCR.
will be there. Everything will be there. Lordship.
Okay.
Then lordship, scan copy of that, sir. Even lordship, the next date is, it's in the month of November, lordship.
Okay,
Till
before
then-
November, we will fix the matter. Heard
Lordship.
Mr. Islam, learned counsel for the petitioner. Also heard Ms. R. Soduri, learned senior counsel assisted by Ms.
M.
M.
Bordole.
Bordole, learned counsel for the respondent. Madam Bhoya, you are here?
Lordship, just formal part.
Okay.
Or one, lordship.
Madam Bhoya, learned senior counsel come additional PP for the state respondent number 1. After hearing learned counsel for both the parties, perusal of the record is highly necessary. And accordingly, it is provided that RSSL call for the scanned copy of the record from the learned trial court, fixing the matter on Kaveh, 16th of September.
Lordship, may I pray in the meantime, the impugned order may kindly be stayed,
The
Lordship,
next
because
date is in the month of
the-
November. Before that, we can dispose, Lordship. And this is a
Because-
part-heard matter,
because
Lordship.
this, for this, the order of the impugned order, every date in the learned trial court, we have to file a petition that payment have to be made, Lordship.
Because,
But
Lordship,
if
impugned
the
order-
next date is fixed in the month of November,
Yes, yes.
and then before that,
there is
we
no
will
need
dispose
to
of the
file any
matter.
application, Lordship.
RSSL on next date, an endeavor will be made to finally hear and dispose of the matter.
Yes.
You keep the certified copy and this decision with you.
Lordship.
May I please, your Lordship?
But in my instance, this has come up, Lordship, take up my affidavit, my lord. In the meantime, he was convicted and the other complainant, my lord, in the enact case, my lord. In the meantime, that their compromise has taken place, my lord. If Lordship take up my affidavit, my lord. Page number 82, annexure B, my lord. No, my lord, annexure A, it starts from annexure A, my lord. There is some very compromise taken place, my lord, and they have exchanged that money.
This is of NIA.
Enact, my lord.
Where is the affidavit?
My lord, it starts from page number, response number 274 onward.
Mr. Bora, you are for the respondent number 2.
2. Some confusion even if page number it starts. The annexure 1 and 2, my lord. Annexure 1, there is a declaration between that that second place, and annexure B, my lord, that money has there. 4 lakhs payment cash amount has been paid to the complainant too, and that grievances is over, my lord, for the response number 2, the complainant.
Entire amount was paid.
Entire amount was paid, my lord.
Yes, sir.
You have received.
No, I am the complainant. I have received.
I
Oh, you
was,
have received.
Yes, sir.
Okay.
My lord, friend, my lord, during pendency of this revision petition, my lord, they have
Matter
settled
was
the matter.
compromised.
Yes, my lord, and full payment, my lord, I have paid and he received, my lord. So he has no objection. He is mentioned in paragraph 7 of his affidavit that the complainants, so and so have no grievance if the honorable court set aside the conviction upon the settlement between the parties. my lord. Okay, my lord. Both the original court and appellate courts judgment may be set aside. I am clear.
Original code will be sufficient.
And now already been appellate court also there.
Before the appeal, there also it was appeal.
Yes.
That's why. my lord.
And on recent judgment, my lord, if I may be allowed. Yes.
Problem, lord.
Lordship, may I please, your lordship, lordship, humble submission, lordship. For item 26, lordship. Kindly, it may be on Wednesday or Friday, lordship. Very urgency matter, lordship.
Wednesday.
Much obliged, lord.